swear by Almighty God.
I swear by Almighty God.
That I shall tell the truth.
That I shall tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Deputy.
At around about the late hours of Thursday, the 25th of February 1993, were you walking home from your father's house?
Yeah, I was.
And were you accompanied by anyone?
My daughter.
Which route home were you walking?
Through the lone path.
I'm sorry?
It's called the lone path, yeah, I did.
Yeah. Did you notice anything unusual when you got there?
At first I thought it was rubbish, lying at the side of the bridge.
Yes.
It was my daughter, noticed it was a body.
And what did you notice when you approached the body?
It had blood coming from his head. It had a few facial injuries.
Was he making any sound?
At first I thought he was snoring.
Yes.
I loosened his tight clothing round his neck. I saw he was still breathing.
Can you look, please, at production number 4, photograph I. Now, whereabouts was the body? Could you just point on that photograph?
A little cutting. There's a little path leading down to a housing estate.
Yes.
He was lying just at this side of it.
Yes.
The man lying beside the lone path was Matthew Fleming, a retired civil servant. He'd been attacked as he walked home from the Ferns pub. He never regained consciousness, and 2 days later he died. The lone path became the focus of a murder investigation led by Detective Inspector Donald Stewart.
There was absolutely nothing to go on at that time. The simple fact that the man appeared to have been severely beaten about the head. But as far as evidence to lead us to any particular motive or accused for this crime, we had none.
The police did have one clue to the killer's identity. When Matthew Fleming was found on the lone path, there were 2 watches by his side. One was identified by his family as his, but no one could explain who owned the second watch.
At that stage, all we had was the watch. We didn't know whose watch it was. We didn't know really how it had got there. If we could trace the watch back to whoever had lost it, perhaps we would be able to identify the person who had attacked Matt Fleming.
For 3 weeks, rumours spread through the housing schemes of Livingston Newtown. One by one, suspects were eliminated until the only one left was 23-year-old Andrew Deakins.
It was not known to me personally, but he was known to other officers as being someone who lived in Livingston, who had a petty theft background, but had never been in any major trouble.
Andrew Deakins had been seen talking to Matthew Fleming in the pub, and the police had become suspicious about apparent discrepancies in his account of the route he took home and the clothes he was wearing that night.
By the 19th of March, we had been looking for Andrew Deakins to speak to him about these discrepancies, and he had phoned the police station and came in voluntarily.
The police had questioned Andrew a couple of times, and they were now looking for him to question him further, and he didn't want to go into the police station his own. So I arranged to meet Andrew, a location out with the police station first of all, so I could have a chat with him out with the presence of any police officers, so I could obviously properly advise him. And after that, we decided that we'd then walk into the police station.
By 11 o'clock that night, the police had reached a decision.
At that stage, I told Andrew Deakins that I was going to detain him under Section 2 for the murder of Matt Fleming. He replied that he didn't do it. I never done it, he said, and that was his reply. So we had no admission or any story from Andrew Deakins to implicate himself in the murder. Nothing whatsoever.
For 4 months, Andrew Deakins has been held on remand in Saughton Prison. He has always insisted that he knows nothing about the killing of Matthew Fleming, that he may be a petty thief, but he is no murderer.
I've got 1 assault on my record. That's it. But I've never been a violent person in my life. That assault I got on my record was through drink, because I had a drink problem at the time. But apart from that, I've never been violent in my life, and if you ask anybody that knows me outside, they'll tell you the exact same thing as well. I'm not violent.
Cabbage, no?
Everything about it just stinks. Because I don't see why my family should be split up for 4 months just because the police were wrong and they should get away with it. I just don't understand it at all.
In Edinburgh High Court, the Crown has assembled its evidence. And for Andrew Deakins, the waiting is now over. Within 3 days, the Deakins family will see Andrew either walking from the court as a free man or starting a life sentence as a convicted murderer. The question of his guilt or innocence will be decided by a jury of 15 men and women. The defence of that innocence has been prepared by solicitor Callum Ross and will be articulated in court by his advocate, Gordon Jackson.
When I first saw the papers, the case was depressingly normal in that a man had been kicked to death on his way home from a pub. But the evidence was unusual in that there was no eyewitness, there was no admission, there was no real forensic evidence, that is, blood staining transferred onto clothes. There were just pieces of circumstantial evidence which the Crown were going to try to add up into a case.
The judge is Lord Sutherland, one of the most senior in Scotland. Trying to prove Andrew Deakins' guilt is the Advocate Depute Scott Brady.
Is your full name Basil Nigel Purdue?
Yes.
And are you in the Forensic Medicine Unit, Department of Pathology, University of Edinburgh?
Yes.
On the 1st of March, did you conduct a post-mortem dissection on the body of a man who had been identified with you as Matthew Fleming?
Yes, I did.
As Matthew Fleming. Could I ask you, please, to look at production number 4, photograph AF? Can you confirm for me, first of all, that that is the deceased person that we're talking about and that he was in that condition when you saw him?
Yes, sir.
Could you hold that up for the ladies and gentlemen of the jury, please? And do we see really the whole facial area and the head area being swollen there?
Yes, he's apparently very moon-faced.
Yeah. Have you seen a photograph of the man as he originally was before he came to you?
No, I haven't.
Could you look, please, at photograph AO, which is in that selection of photographs? And I wonder if you could hold that up for the ladies and gentlemen of the jury. I think we can see it's a matter of common observation, at least, that the head appears to be much more swollen in the earlier photograph. Is that correct?
Yes, the shape is quite different.
Thank you.
We examined the face in some detail internally. This confirmed that both cheekbones were completely free-floating. The upper jaw was completely free-floating as well.
Now, can I ask you to perhaps explain what you mean by free-floating? What does that mean?
The implication is that the whole of the skeleton of the face, from a level just below the eyebrows to the corners of the mouth, was completely fragmented, broken up into pieces and moving around.
What could have caused these injuries?
The application of severe and repeated blunt force.
You record there the cause of death as bronchopneumonia and severe facial injury, is that correct?
Yes, the bronchopneumonia being caused by the severe facial injury. Blood has run down the throat into the air passages and has actually starved the brain of oxygen. He has been unable to breathe properly. As a result, his brain has swollen and been severely damaged by lack of oxygen. And I think that much of his chest infection and subsequent fatal complications are based in this damage to the brain.
Thank you very much.
Dr. Purdue, can I just make sure I understand one or two things completely? The man who died has obviously been struck about the face.
Yes.
And he has presumably bled from that.
That's right.
If he is not able to deal with the blood, it will run into lungs and airways, that sort of thing.
That's right.
If, for example, there had been blows to the face and bleeding, and someone had been there to stop the blood, I put it this way, going into the airways, then we would not have had this causal link right through.
I think there's a large measure of luck involved in deaths of this kind, or ill luck. If medical treatment is rapid and someone is placed in a position so that the blood comes out of the body and not straight down the air passages, then there is a much better chance of the person surviving the injuries.
So, as you put it, there is luck or ill luck because these injuries are not in themselves the sort of injuries from which one would inevitably die. It depends on the course, literally the course of the blood thereafter.
People have survived injuries of this sort.
What we're trying to do is have the man totally acquitted, but in the back of the mind is the possibility that he's going to be found guilty. So in that situation, you want the jury to find him guilty of culpable homicide rather than murder. Culpable homicide is where someone dies in the course of an assault, but the assault is not as serious or as vicious as a murderous assault. So how the man died, how much force was needed to kill him, how easily he succumbed, becomes relevant to that question. In this case, we know, I think, from your report that the blood alcohol level at time of admission to hospital is 249 milligrams per whatever it is of blood.
Yes.
It's maybe something like 10 pints.
Yes, something of that order.
Would it affect, do you think, even consciousness or ability to deal with blood? We have situations where a man with drink obviously lies on his back rather than turns himself over. Would it affect that here at all?
It's hard to apportion blame, if you like, between the drink and the injury, but the drink is not a necessary component of the death. This could have happened had he been sober.
Yes, but it might not.
It's another loading of the dice against the deceased.
Yeah. Okay.
Well, ladies and gentlemen, it looks as though we're having an early lunch today, so we'll adjourn now for lunch, and we will resume, if at all possible, by 1:30, perhaps about 20 to 2. It depends on the catering arrangements.
At the early hours of Friday the 26th of February, were you on duty?
I was off duty and called out.
And what were you called out to?
I was called out regarding a man having been found in the footpath.
Now, have you had occasion to interview a number of people in connection with that inquiry?
Yes, there was a squad for him to interview various witnesses.
Did you have occasion to interview a person called Andrew Deakins?
I did, yes.
And are you able to recognise him again?
Yes, that is Mr. Deakins.
Andrew Deakins twice told the police that after leaving the pub, he had gone to a friend's house but found no one at home. He said this detour had taken 35 minutes, but the police believed he hadn't arrived home until 2:30 a.m., 2 hours after leaving the pub. When questioned a third time, he gave a different explanation of his route home.
And on this occasion, when he was speaking to you here in the police station, what did he tell you he did on his way home?
He told us that after leaving the Ferns public house, he had not gone to his friend's house as previously indicated, but had taken a circuitous route via Brisbane Street, where he had stated he had been looking for something or to steal.
And what premises was it that he indicated that he had attempted to break into?
He indicated that he had tried to break into British Telecom at Forest Bank in Livingston. I caused officers to go to the premises of British Telecom to examine it, to see if there was any signs of any attempt or any break-in there.
Were you satisfied with the explanation that he gave to you about his movements on the night of the 25th of February?
Not at all, no. The indications were that there had been no attempt made to break into those particular premises.
In Livingston Police Station, the investigation team noticed another inconsistency in his response to questions. This concerned the clothes he was wearing that night.
Now, what descriptions had you received of clothes that he'd been wearing on the night in question?
He was described to us as wearing a green T-shirt, jeans and green or turquoise coloured trainers.
What was he claiming to be wearing that stage?
He was claiming to have been wearing jeans, brown shoes and a brown leather jacket.
Yeah.
This was contradicted by 3 people who had been playing pool with Andrew Deakins. They later gave evidence saying that they could clearly remember he was wearing jeans and green Nike Air Max trainers.
He stated, well, I had trainers like that, but I threw them out because they were burst. I asked him when that was, and he said it was a week after his birthday. I asked him when his birthday was, and he stated his birthday was on 17th of February. I said, a week or so before this happens, you don't have them on that particular night? He replied, no. I asked him why people said he was wearing clothing like that, and he replied that he did not know.
The suggestion is that he went out wearing the jeans and training shoes. By the time he got home, he had changed them. And obviously the prosecution are going to say that that is sinister, that someone who changes is doing it for a reason. And they'll suggest that you would get blood on those items if you kick someone to death.
Admitting he had changed his jeans, Andrew Deakins offered a less sinister explanation. This related to the attempted break-in he had spoken about.
I asked him where were the jeans that you were wearing. He said, in the bin. I asked him, why did you change them? He says, because I tore them.
And where did he say that he'd torn the jeans?
He said he had torn the jeans in a fence, and there is a fence surrounding the premises of British Telecom. And I replied, so you tore your jeans, but you just happened to be wearing a pair of jogging bottoms under them? He replied, mm-hmm. And I asked him, did he normally do that? He stated, now and again. I asked him why he wore jogging bottoms under his trousers, and he says, sometimes it's cold.
Yeah.
I said, was it cold that night? He replied, aye.
Thank you very much.
Mr. Jackson.
Mr. Deakins told you about some break-in at British Telecom.
Yes.
And that was supposedly taking place some weeks before.
That's correct, yes.
And you could find in your inquiry no evidence of that.
That's correct, yes.
Could you have in front of you, please, number 13, production 13? Is, I hope, the transcript of another interview, but earlier on the same day. Is that right?
Yes.
You asked the question, would there be any sign that you had been there?
Yes, that's correct.
And he says, don't know, there might be.
Yes.
So, to be quite fair, he wasn't describing something that he was saying there would be evidence of.
No, that's correct.
It's not as if he's describing smashing windows or something and saying to you, if you go, you will find evidence of this.
He stated that he had tried to boot the door in.
Sure. So he certainly, when asked, will there be signs of this, he does not say there will be, he says he doesn't know.
That's correct.
Right. Later that day, and of course, finally, you charge him with murder, and then you go through the normal question where you say, do you understand the charge?
Yes.
And he says, aye.
Yes.
And then you say to him, do you wish to say anything?
Yes.
What does he say?
He replied, aye, I never done it.
I never done it. So he's given you certain information about various items of clothing, information about British Telecom, and when you charge him with the murder, he makes what might be said, in fairness, to be a very straightforward denial of that.
Yes.
Cool.
Thank you, Inspector. That's all.
Anything else? Just give me this. Come on, son. Right. Okay, over there and change that.
Sign his card. Hello, Nick on reception. You're getting Deacons back in a couple of minutes. Right, okay, I'll get somebody down as soon as possible. Okay, cheers.
Here's that.
Okay. Here. Right, okay, take him back to the hall.
Andrew Deacon's chances of not becoming more familiar with prison routine depend largely on the evidence of Amanda Macmillan. She is the mother of his one-year-old son. They are unmarried.
A wife can refuse to give evidence, but no one else can refuse. And in this culture, less and less people actually get married, so it becomes more common for someone in that position to end up being a witness.
Amanda has already told the police that she recognized the unidentified watch found next to the body of Matthew Fleming.
The girlfriend is the crucial witness because she identified the watch. But more importantly, she said that he had been wearing it less than a day before the crime had taken place. I want to go back over the girlfriend's statement. She speaks about the watch, and she describes it in detail with bits on the strap missing and scratches on the glass. But the main point is she says she saw you wearing it. This is what she says, on the Wednesday, which was the day prior to this man being killed. Now, is she wrong in that?
She was wrong about that, aye. The last time I seen it was the end of January, and that's when I came back from Glasgow.
But when's the last time she actually could have seen you wearing it if she was remembering it right?
My birthday, probably.
Which is?
17th of February.
Why do you think she's saying that about seeing you wear it the day before? Do you think she's getting the days wrong, or do you think the police have told her to say that, or she's just getting frightened?
Maybe she's got the days wrong. I mean...
The watch is obviously an important thing, and obviously the most important one is your girlfriend. Depends what she actually sounds like. She may turn up and sound very confident about seeing you with the watch. That's a problem. She may, when she's asked, say, I'm not sure when I saw it. It's not a problem. So there's just no way of anticipating it.
We had great fears for her evidence in terms of the damaging effect it would have on us, because she linked the whole thing to us. The watch is linked via Amanda. The change of clothes is linked via Amanda. Everything stemmed or went through Amanda's evidence. Okay, so see you tomorrow morning, Andrew. Take care, try and get a good night's sleep and we'll see you tomorrow. Okay, do your best for that anyway.
I swear by Almighty God
I swear by Almighty God
that I shall tell the truth,
to tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Is your full name Amanda Jane Macmillan?
Yeah.
And what age are you, please?
21.
And did you formerly reside at Erskine Way, Knightsbridge, Livingston, West Lothian?
Yes.
And did you live there with your son, John Paul?
Yes.
Who is your son's father?
Andrew Deacons.
And was he your boyfriend at that time?
Mm-hmm.
And can you see Andrew Deacons here today in court?
Yes.
And where is he sitting?
Yeah.
Now, did he live with you at Erskine Way?
Yes.
Amanda saw Andrew at their house on the afternoon before Matthew Fleming was killed, and was later woken when he returned home in the early hours. Although several witnesses have already told the court that Andrew was wearing training shoes and jeans when he was in the pub, Only Amanda can testify to what he was wearing at the time he returned home.
When you saw him at 2 a.m., what was he wearing?
He was wearing black tracksuit bottoms.
Black tracksuit bottoms?
Yeah.
Anything else?
And brown leather shoes.
I'm sorry?
Brown leather shoes.
I see. Could you look, please, at label number 6? You just hold these up. I think we can evidently see what these are, but do you recognise them?
It's a black tracksuit bottoms.
Black tracksuit bottoms. Have you seen them before?
Just when Andrew came home.
And were those the ones he was wearing?
Yeah.
And could you look, please, at labels 3 and 4? Have you seen these before?
Yeah.
These are the shoes, are they? Yes. Had you ever seen these brown shoes or black tracksuit bottoms before?
No.
Now, the next morning, was the accused with you?
Yeah.
And had he stayed the night with you?
Yeah.
And did you discuss what he'd done the previous night with him at that stage?
No.
Did you ask him why he'd appeared, at least to you, to have changed his clothes?
No.
Never asked him that at all?
No.
Under police questioning, Amanda had initially supported Andrew's story that he'd been wearing the jogging bottoms underneath his jeans.
I went to see Andrew before I went to see the police, and it was then Andrew said to me that I was to tell him that he had the tracksuit bottoms underneath the jeans. I just kept to the story that Andrew had said.
The unidentified watch found next to Matthew Fleming has become label 1. The question is whether Amanda can and will say that it belongs to Andrew.
Now, prior to that, had you given Andrew a watch?
Yeah.
Could you look, please, at label number 1? Now, do you recognise that?
Yeah.
Is that the watch?
Yes.
This watch, which it is said belonged to him, is found next to the body of the dead man. That's the most important piece of evidence for suggesting that the accused is anywhere near the dead man. Without the watch, there is no case at all.
Now, how is it that you recognise it?
The scratches on the face, there's the paint marks on the strap.
You can actually recognise the scratches, can you? Whereabouts are the scratches on the face, then?
There's a scratch between the 1 and the 2, and just across the 6, and one pointing at the 4.
Now, how do you know that, how is it that you can tell that that was the watch that you gave to Andrew by these scratches?
There were some scratches on the watch when I gave Andrew it.
Now, you said something about paint. What was that about?
Well, Andrew used to decorate some of his cousins' houses, and he was wearing the watch, and that's how the paint got on there.
And can you recognise the paint on it?
It's white paint.
I'm sorry?
It's just white paint.
Yes, but can you recognise where the paint is? I mean, have you seen that paint on that watch before?
Yeah, because we were trying to get the paint off the straps.
And the third reason that you can tell the watch is because there was something wrong with
the band there is missing.
That is the thing that you put the tongue of the strap,
yeah,
as it were, through, and that's missing.
Yeah.
Did you provide the police with a photograph of your boyfriend with his watch on? I see. Could you look, please, at photograph production number 4, photograph AN? Do you recognise that?
Yeah, that was taken when we were in hospital.
When you were in hospital? When was that?
When my son was born.
I see. Could you just hold that up for ladies and gentlemen of the jury? And it's quite clear there's a man's arm on that, and there's also a watch on the arm. Do you recognise that watch?
Yeah.
And can you remember when the last time was that you saw the accused wearing that watch?
The Wednesday.
And how do you know he was wearing it on the Wednesday?
When we had went to bed that Tuesday night, John Paul, my son, woke up. I went and put the watch on.
And was that to check the time?
Yeah.
Now, did you give that watch back?
Yeah.
I see. And did you see him putting it on? When was that?
That was on the Wednesday.
Thank you very much.
As far as the watch is concerned, as far as you're concerned, that watch looks the same as the one he had.
Mm-hmm.
It's got a scratch face and certain marks on it.
Yeah.
When were you first asked about the watch? Obviously today is not the first. You must have been asked about it by police officers or someone anyway.
Just before he got lifted.
That's weeks later.
Yeah.
And you then had to think back to when you had seen the watch.
Yeah.
And you placed it as the Wednesday before that Thursday.
Yeah.
Is that something you're sure about? It was that Wednesday, or it might have been an earlier Wednesday?
No, it was Wednesday.
Yes. What is it that fixes it so many weeks later as being that Wednesday?
Because I used the watch that on a Wednesday morning to see what time my son got up at.
Yes, I appreciate that, and perhaps we're going round in circles, and that's my fault. But what is it that makes you look back over a period of weeks and say it was that Wednesday, and maybe not the Wednesday before or even the Wednesday before that? How do you fix it to that Wednesday so many weeks later?
Because I can't remember seeing it after that Wednesday.
All right. But were you remembering it was that date, or you remember it was just a Wednesday? How do you know it was that Wednesday that you had this incident where you put the watch on and not an earlier Wednesday?
Because it was that Wednesday.
That was your recollection weeks later?
Aye.
Okay. Okay. She's more definite than I thought she was going to be. She's very definite about the watch actually belonging to him. She's also fairly definite about when he was last seen wearing it by her. And she's very definite about what he came home with. But from my point of view, it doesn't matter very much, because none of that's really a matter of any great dispute. I checked to see how definite she was, but there's no great problem in any of it as far as I'm concerned. This case isn't about disputing evidence, it's about what interpretation you're entitled to put on evidence that's there.
The prosecution case is now over, and Andrew Deacon's lawyers have decided not to call him to give evidence in his own defence.
Ladies and gentlemen, I should just explain that Mr. Jackson has said that there will be no evidence laid on behalf of the accused, and accordingly that is all the evidence that you will be hearing in this case. What happens now is that you will be addressed by the Advocate Depute and then by Mr. Jackson, and then after that I shall have to give you directions on matters of law. Yes, Mr. Depute.
Ladies and gentlemen, it is the Crown's position in this case that Andrew Deacons murdered Matthew Fleming. And it is the Crown's position that he did that by beating him repeatedly on the head and leaving him in a crumpled heap on the walkway to die.
The Crown case is to show that he was with the man some hours before he was killed, that the watch we owned was next to his body, and that we had changed our clothes by the time we got home. And I've been fairly successful in showing that.
What I invite you to say that it points to is that the accused, after beating this man into such a state that he subsequently died, had become covered in blood on his trousers and on his shoes. And you heard evidence from the forensic pathologist. And in those circumstances, ladies and gentlemen, given the evidence in the case, I invite you to convict the accused of this crime.
It's my function to say something to you on behalf of the man who's charged with this crime. When tomorrow you consider your verdict and come back, you will not be asked by the clerk of court who killed the man. It is not a whodunit. This is not sort of 15 amateur detectives trying to work out who is responsible. That is not for us to do that. The question, and the only question, will be what has been established about this man. The Crown need to prove the case beyond reasonable doubt. Now, that sort of phrase frightens me because it is such a well-known phrase, beyond reasonable doubt. It's on the telly. Soap operas, anything else the telly care to deal in, end up using this phrase beyond reasonable doubt, and it becomes like a game that lawyers play with. We sit round the table, we dress in rather quaint and peculiar clothes, and in the end of the day, phrases like beyond reasonable doubt become a sort of game, but they are not a game. They are, in fact, at the very basis of our system. Let me try to put it my way without worrying at the moment how his lordship likes to put it. This man is brought here and he is suspected because he's the candidate as far as this case is concerned. And you, all of you, go away and you consider what you make of it. And all of you unanimously decide it was not he. You would come back and you would acquit him. That's obvious. But all of you might go away and unanimously decide what we think is he did it. That's what we think. We think, if you were asking us, he did this murder. He killed the man. In all probability, it was him. You would come back in here and you would acquit him. I hope that's clear. It's only when you get somewhere beyond that that you end up saying, we will convict a man of murder. Now, the evidence in this case isn't there. There is no motive. Not that we need it, I know, but there is none. There is none. Not a scrap. There is no identification of anyone seeing anything. We do not have a witness who comes along and says, yes, I saw a man run away having kicked another man in the head, and then quite dramatically pointing to the dock and saying it is he. We don't have that. We don't have any admission of guilt. Quite often we do, it may surprise you, where people eventually under police questioning end up saying, yes, you're right, I was involved in some way or t'other. We don't have any forensic evidence. We have no blood staining that matters. We have no scientific evidence. The normal sort of evidence that is used to bring home guilt beyond reasonable doubt does not exist. So the Crown say, well, let's cobble it together from somewhere else. What do they cobble it together from? Clothes that may or may not have been changed, and a watch. What the Crown say is there is a watch next this body. And we can do two things. We can demonstrate beyond reasonable doubt that particular watch is his watch. And then secondly, having demonstrated it is his watch, you can then somehow jump to the conclusion, make the leap, that shows, as the Advocate Depute started with, he came along, waylaid him, knocked him to the ground, kicked him all over the place, got blood in his clothes and went away. It's a nonsense. It's a frightening nonsense. Let me assume, for example, you could prove beyond reasonable doubt it was his watch. What would that tell you? It's not like his fingerprint says he was there. I could stand here and for the next 5-10 minutes suggest to you maybe a dozen things that could possibly prove. The Advocate Depute has the one that suits him. It's his watch. So he was there? Maybe. So he saw what happened? Maybe. So he stopped other people doing it and won't tell us who it was? Maybe. I'm making it up as I go along. I make no bones about that. Or someone else gets it, someone else steals it, or it is dropped in the pub and someone else picked it up. My theory is as good as anyone's theory. We are talking about proving a person committed a murder because, for the sake of argument, a watch which they own is found next to it. It is some huge jump, that. But that is what it comes to. On that sort of evidence that a murder has been proved. It hasn't. And that's why I lead none, because there is no evidence I need in that situation. And I will not play at games, because the Crown don't have it, and the Advocate Depute saying it won't make it, and nothing will change it, and it's not there.
It was a fantastic speech that Gordon did there, Mr. Jackson. Just a classic speech there, one we can all learn from. At the end of the day, nothing more we can do now, Andy.
No, I appreciate that, Callum. You've done your best, what you can do.
So, what we do is come back tomorrow, listen to his lordship's charge. They say you only get one shot at it, and that's your best shot at it.
Certainly.
And then it's the waiting game. Okay, see you tomorrow. Okay.
See you later. Cheers.
See you tomorrow morning.
Are you feeling more relaxed now?
A lot more relaxed after today, because I just noticed what the QC is really there for. When it wants to give his speech and his summing up, and it was brilliant. And obviously he's filled the jury's minds with a lot of doubt. So hopefully I'll just wait till tomorrow and see what the judge's got to say, and then see what the verdict the jury come back with, before I decide what I'm going to do with the rest of my life. As far as I'm concerned, they can't prove beyond all reasonable doubt that I've done this murder.
In the morning, the judge, Lord Sutherland, will address the jury. They will retire to consider their verdict, and Andrew Deakins will wait for them to decide whether or not he is guilty of murder.
Now, ladies and gentlemen, let me first explain to you our respective functions in this case. My function is to deal with all questions of law. Your function in this case is to deal with all questions of fact. Questions of fact are entirely and exclusively for you. What you are looking for in a circumstantial case is looking at a number of bits and pieces of evidence which, when added together, fitted together rather like a jigsaw puzzle, make sense and make it clear to you what the full picture is. So like a jigsaw puzzle, you may pick up one piece and it means absolutely nothing to you at all, and you have no idea from that piece what the whole picture is meant to be. But when you start adding bits together, even though some of the pieces may be missing, you may still have a perfectly clear picture of what is the end result is intended to be.
Lord Sutherland's summing up lasts for 45 minutes.
Now, ladies and gentlemen, murder is committed by any willful, that is to say, intentional act causing the destruction of human life, either intending to kill the victim or acting with such wicked recklessness as to display a disposition depraved enough to be regardless of the consequences. If you are not satisfied that the assault in this case comes up to that standard, then you could return an alternative verdict of guilty of culpable homicide. In the case of culpable homicide, there must obviously be a death, but death does not require to be a foreseeable result of the unlawful act. Your concern is to decide whether the Crown have proved that it was the accused who assaulted Matthew Fleming, and if so, whether that crime constitutes murder or culpable homicide. And now, ladies and gentlemen, will you please retire and consider your verdict.
All that's left now, it's in the hands of the jury. Well, I hope the best for you. Nothing more can be done. I don't think there's anything else that could have been done. I think we've covered it. And it's just in their hands, and nobody can foretell what can happen there. Okay. I thought it was quite fair, very fair indeed. If you think about what he said about Mr. Jackson, he told the jury specifically to consider deeply what he said. I mean, he categorically told them if they didn't accept the watch, and that's it, it's finished. They must return an acquittal verdict. So we'll just have to wait and see what they return on that piece of evidence. So it's been really left by and large in the hands of the jury. Okay? Nobody can predict what happens now.
You want to get another shot on him?
No. No other shots, that's it. Okay. Okay.
Members of the jury, will your spokesman please stand? Have you reached your verdict?
We have.
In respect of charge 1, what is your verdict?
Guilty as libelled.
Is your verdict unanimous or by a majority?
By majority.
Thank you. Please be seated. I now have to record your verdict. This will only take a moment or two. I'm going to read back to you your verdict as I've recorded it, and you can confirm whether it's an accurate record. The jury, by a majority, find the accused Andrew Deakins guilty as libelled in respect of charge 1. Is that a true record of your verdict? Thank you.
Andrew Deakins, you have been convicted of the crime of murder, and for that crime there is only one sentence that I can impose. That sentence is that you be imprisoned for life. That is all. Ladies and gentlemen, it only remains for me to thank you for the care and attention which you have obviously given to this far from straightforward case. The court is always very grateful to citizens who give up their time to act as jurors, and it is essential that we have jurors in order that people may be tried in accordance with our system of justice. I'm very grateful to you, and I'm now able to discharge you from any further attendance. Thank you very much.
Court.